The Gestapo by the Ekiti State Police Rapid Response Squad (RRS) unit at the instance of Chief Are Afe Babalola on grounds of defamation has harvested baskets full of comments within and outside the legal province. This brouhaha derives from the literary work of Dele Farotimi, a lawyer and human rights activist, Nigeria and its criminal justice system. What is defamation? A defamatory statement may be defined as one which tends 1. To lower the plaintiff in the estimation of right-thinking members of society generally, or 2. To expose him to hatred, contempt, or ridicule, or 3. To cause other persons to shun or avoid him, or 4. To discredit him in office, trade, or profession, or 5. To injure his financial credit. Ingredients of defamation. For a plaintiff to succeed in defamatory action, he must establish 3 things. 1. That the words were defamatory. 2. That the word referred to the plaintiff. 3. That the words were published to at least one person other than the plaintiff. Beyond civil action. By the provisions of Section 375 of the Criminal Code Act, any person who publishes any defamatory matter is guilty of a misdemeanor and is liable to imprisonment for 1 year. And any person who publishes any defamatory matter knowing it to be false is liable to imprisonment for 2 years. However, Section 377 of the Criminal Code deals with the publication of truth for public benefit. Specifically, it states that the publication of defamatory matter is not an offense if the publication is, at the time it is made, for the public benefit, and if the defamatory matter is true. Forms of defamation. Defamation can be in one of 2 forms, libel or slander. Libel refers to a harmful statement made in a permanent or written form, such as books, newspapers, letters, paintings, photographs, film, radio, or television broadcasts. The motive of malice and having suffered a loss is not necessary to prove libel. Slander is a harmful statement made in a non-permanent form, such as by speech or gestures. Those accusing someone of slander have to prove that the harmful statement has caused some loss, which could be financial or moral. Defenses to defamation. 1. Plea of justification. A plea of justification is a complete defense in a claim for libel. Evidence that the appellant has been convicted shows that he has no reputation which he claims, and it establishes the truth of the publication. 2. Fair comment. Requirement for defense. The matter commented on must be one of public interest. The statement must be a comment or opinion and not an assertion of fact. The comment must be based upon fact truly stated. For comments to be fair, it must be based upon true facts in existence when the comment was made. One cannot invent untrue facts about a man and then comment on them. The comment must be honestly made. A comment may be fair for the purpose of defense of fair comment, notwithstanding that it is violent, exaggerated, biased, or clearly wrong, provided it was honestly made. The test is not whether a reasonable man would hold and express such an opinion, but whether the defendant honestly expressed his real view. The comment must not be actuated by express malice, vulgar abuse. It is well established that words spoken as mere vulgar abuse or insult are not actionable in slander. Whether particular words constitute slander or mere vulgar abuse depends upon the circumstances in which they are spoken. Thus, for example, if A calls B a dirty whore at the height of a violent quarrel, this may be mere vulgar abuse and not actionable, but the same words spoken in cold blood would be slander. When the thought of defamation is chiefly a civil wrong and requires no interference by law enforcement agencies, Section 375 of the Criminal Code creates it to be an offense. This message was brought to you by DMJ Ononuju Obiaga and Co-Analyst. Like, comment, and share our videos.